Good evening, everyone. So, as we know, today we are all gathered here for a webinar on IPR for patenting innovations and inventions that is being organized by World Cybersecurity Forum. And the key speaker for the evening is Mr. Sandeep Gupta. So, before we delve into the seminar, I would want to briefly introduce the organization World Cybersecurity Forum, also known as WCF. WCF is an internationally renowned cyber consultancy and web community that aims in improving cybersecurity awareness and acts as a source of techno-legal information for the students and for the professionals in the field. And it also offers a blend of original content from IT professionals, peer-to-peer advice from the largest community of IT leaders, and has an extensive library of professional resources from leading IT industry vendors. About today's webinar on IPR for patenting innovation and inventions. As we know that IPR, intellectual property rights itself, is a burgeoning sector that not only protects owners, artists, and writers in safeguarding their work, but also opens up a slew of opportunities for young people and professionals, both legal and technical backgrounds in the field. Whereas patent grants its owners an exclusive right to prevent others from taking advantage of the owner's creative idea. The knowledge of patents grants is itself provides a good career opportunity to both the legal and tech students. So today's webinar is going to provide us a guide and also going to discuss our upcoming courses on patents. And so the topics that are going to be briefly covered in today's webinar are: what is the need of patenting, the career opportunities,
Hello, Sabrina. Shall I start?
So just a second. Okay. As I was talking about the topics that are going to be covered in today's webinar are the need for patenting, the career opportunities in the field of patent laws, the national and the perspectives on national and international patents, the types of applications involved in the filing process, And before we start with the webinar, I would also want to tell the audience about our upcoming course on patents, which is the practical guide to patent laws. It is a 1 month course that is being offered by WCF. The learning outcomes from the course would be the learning on to how to file and draft patents, the scope and limits of patent protection, the analysis and how to analyze and apply the standards of patentability to navigate the requirements of patent law. The benefits of enrollment would be the participants would get an e-certificate and would also gain practical skills. And the actual cost of the course is rupees 999, but WCF is offering it at a discounted rate of rupees 699. And those who enrolled today itself after the webinar would get an additional 10% discount after which could be availed after using the coupon of cyber learning 10. So before Sir takes on the floor, I would want to give a brief about Sir. Mr. Sandeep Gupta is a patent agent and advocate who is highly skilled in intellectual property matters, specifically related to patents, including their drafting, prosecution, analytics, and much more. He is an alumnus of Faculty of Law, University of Delhi, and is currently working as an IPR attorney at Uflex Limited. He has also worked as an examiner of trademarks with the Office of Controller General of Patents, Designs and Trademarks. So you can continue.
Hello. Hi all. Thanks, Sabrina. So basically today's session is about patenting and innovation and about what is the criteria of patentability and different aspects of patent applications, patent law, what a student must know, and for the students who want to make a career in patent laws. For example, today everybody when listen news, there is a ongoing conflict between China and USA. If you go deeper into these things, why there is an issue between China and USA. Everybody has listened about 5G technologies. If you go deeper into the patent law, you will know that the most of the patents in 5G technologies are now held by Chinese companies. Patent war, whether it is visible or not visible, it is a major thing, a fight, ongoing tussle between China and the USA. So any country who controls the technology ultimately controls the world. Initially, it was the USA who was controlling the technology and leading the world. Same now, China is expanding its footprints in 5G technology and owns most of the patents in 5G technology. So this is also one of the main reasons of the war. I just for the sake of the knowledge of peoples, I want to I tell you this fact now. Again, now I'm starting my topic. Intellectual property and especially patents are widely considered to be the lifeblood of innovation, which in turn creates new sources of growth and prosperity. However, the relationship between patents and innovation is much more complex than acknowledged in much of the current innovation and innovation policy rhetoric. As I have mentioned, that the relationship between patents and innovation is much more complex. You can see that you can relate this thing with the 5G technology of China, who Chinese companies owns most of the patents. So the development is also related with this thing. The company who owns the patent will get most of the royalties from these patents and the technology. You know that a mobile phone is a combination of multiple patents. All patents are not owned by a single Nokia company or a Samsung company or an iPhone or Apple. It is collectively presented to you, but for the each and every specification of this of the mobile phone, iPhone or a Samsung or a Nokia or any corporation has to pay the royalty. royalty to the patent owners. So basically, these are the few things which everybody should know. What are patents? As per Indian Patent Act, patent is a negative right granted by government to an inventor to exclude others from making, using, offering for sale, or selling the invention throughout the United States, India, or importing the invention into the India for a limited time in exchange for public disclosure of the invention when the patent is granted. Basically, as per Indian Patent Act or a US Patent Act, the patent is a territorial right. You have to apply for a patent in individual countries. These rights are limited to the territorial, and also it gives a negative right. Negative right means that you have to go to the court and sue the opponent, sue the person who is making use of your patented technology. In other words, patents are not rights to exploit technology, they are only rights to keep others from doing so, a negative right. That means you have to sue, you have to go to the court of the law, you have to send cease and desist letters, any notices, and you have to take the course of law to protect your rights. Patents are boundaries rather than behind the boundaries. Patents, in patents, basically what is granted? The patent is granted for a claims. That is your boundary. The claims which define your boundaries, that within that boundary you are protected. Suppose A, B, C, D is a component of your patent, and if anybody is using A, B, C, D together, then it is protected. It is protected by your patent, and the law, the government, the Patent Act of respective countries or any is going to protect you. As an exclusive property right, patents invite their use as a strategic weapon to shape markets and to reap monopoly rents through patent monetization. In a sense, strategic patenting refers to increasing the use of patent as market deterrents and as a new asset class. For example, when you have a patent, you can prohibit others from entering the market, or you have a monopoly on that product. When there is a monopoly, you can sell your products exclusively and at a higher cost to recover the expenses which occur during the innovation and research of the patents. So it is a deterrent to the other people's also. For example, when you first invented the product and you got the patent, you have an exclusive right to use that market. And often it happens that who is the owner of the patent controls the market. Initial leaders, when you are an initial leader of a product or an initial entrepreneur of a product, you will in coming years are controlling the market of that product. When a company holds a strategic patent, the competitor must expend efforts to innovate around the incumbent patent owner, which is at a minimum more expensive. In other cases, to avoid the competitor must make product that does not hold comparable consumer appearances. So what to get a patent, a thing must be patented. There are few criteria how a thing becomes patented. So first of all, the invention must be statutory. Statutory means it is defined in the act. In Indian Patent Act, Section 3 and 4 define what are patentable subject matters. Apart from that, if these are if anything falls under these patentable subject matter, Section 3 and 4, and it is a novel, useful, non-obvious, and have economic significance. Novel means ki new. Non-obvious means ki even a person skilled in the art does not know about what is that innovation, that technology, and useful means that has a economic significance. If these four criteria, statutory, it falls in statutory. It is not novel. It is useful, not non-useful or useful, it is non-obvious. These four things determine whether you will get a patent or not. So I am explaining below the patentable subject matters which fall under section 3 and related to atomic energy, section 4. Basically, these are the criteria which determine whether anything falls under the patentable subject matter or not. So, inventions that are frivolous, contrary to natural laws. Inventions which are frivolous or contrary to well-established natural laws. For example, just invention that are against the natural laws, that are any machine give 100% efficiency or any machine gives output without an input cannot be considered as obvious and cannot be patented. And inventions which go against public morality, inventions in which the primary or the intended use or the commercial exploitation of which could be contrary to public order or a morality that is against the accepted norms of the society and is punishable as a crime, or which cause serious prejudice to human, animal, plant life, health, or to the environment. Example, as in biotechnology, termination of the germination of seed by inserting a gene sequence that could lead to a disappearance of butterflies, any invention leading to theft or burglary, counterfeiting of currency notes, or a bioterrorism. You cannot patent a thing which is contrary to the moral law, even if it satisfies the principle of novelty, usefulness, and non-obviousness. Other things are that invention that are a mere discovery of something that already exists in nature. Because the mere discovery of a scientific principle or the formulation of an abstract theory or a discovery of any living or non-living substances occurring in nature, it's not patentable. Mere discovery of something that is already existing or freely in nature is the discovery, not an invention. Because that discovery is not useful, that cannot be monetized, and hence cannot be patented unless it is used in the process of manufacturing an article or substance. Generally, scientific principles can't be used in manufacturing an article or a substance. For instance, the mere discovery of a microorganism is not a patentable. The mere discovery of a form already existing in nature and does not lead to enhancement of efficacy. These are most important in the case of medicines or chemicals. The mere discovery of a new form of a known substance which does not result in enhancement of known efficacy of that substance, or any new property or use of a known substance, or the mere use of a known process, machine, or apparatus, unless such known process results in product or employs at least one new reactant. For example, somebody has a patent for that isomer and you are applying for a patent to the other isomer. So basically, it is a known salt, it is a known ester, it is a known metabolite, but you are applying for a patent for a different salt, ethers, or a polymorph of that product. So it is not mostly not patentable. A mere discovery of any new property or a new use of a non-substance is not patented unless it is of greater efficiency than the original substance. Hence, the mere incremental innovation does not fall under the gamut of patenting. Suppose your original product has an efficacy of 100%. You have invented a method, a product, which is 150% more efficient, and it is patentable. But that you have to put most of the time. Patent office generally put the objection of section 3D, where the efficacy has to be proved, and most of these patents, these objections can be easily overcome. In the Novartis AG versus Union of India, the Supreme Court of India said that mere discovery of an existing substance would not amount to the invention. Existing substance would not amount to the invention, has to be considered. It is an existing substance. A chemical is known chemical is an existing substance. You are just making it more efficient by using an other polymorph or other metabolite, other form of that thing that is not patentable. So there is a new mere admixing or mixtures leading in the aggregation of properties are not patentable. A substance obtained by mere admixing of two or more mixtures resulting only in the aggregation of properties of the components thereof, or a process or producing such substance is not considered the invention. So suppose A and B, you are mixing A and B as a product, and you are getting the product C, and the product C has both the qualities of A and B. It is not patentable. But when A and B is mixed and there's a synergistic effect which produces a different result than A and B individually together, which is not a combination, it is a patentable subject matter. Mere aggregation or duplication of devices working in a known way is not an invention. It is specifically important for the patents of machines, mechanical patents. You are using a part of a machine in the starting or in the end. It is just you are using or using coupling these things. So you are using for example, in packaging a cutter, you are some people use at the time of the pouch making or something at the after filling the product. But as a cutter will not be patentable. Mere improvement or something different matters known before cannot be patentable unless this results in your horticulture and agriculture method is not patentable, because it is against the agriculture. A method of agriculture is not patentable. Any method is not patentable. A method of producing plants like cultivation of algae and mushrooms or improving the soil is not an invention and cannot be patentable. Medical, curative, prophylactic, these are arts. Basically, a horticulture, agriculture method, these are arts. This is not a new invention. It is art, how you do a thing. That's why horticulture is not patentable. Medicinal, curative, a doctor does the surgery, how he does the surgery is not patentable because it is an art. It is not a new invention. He is doing the known thing, but artfully in a better way. That's why it is not patentable. Essential and biological processes for the production and propagation of animals and plants are not an invention. It is same like that plants and animals or a whole and any part thereof, including varieties of species are not patentable simply because these are in existence due to the natural phenomena. Natural phenomena, and you are just aiding the natural phenomena. You are not adding something new. Suppose if in a seed you are inserting a DNA, and that artificial insertion of DNA helps to produce a bigger seed or a bigger flower or a bigger fruit, then it can be patentable subject matter. Simple mathematics or business or computer programs are generally not patentable unless and until they are coupled with any machine or anything. Computer programs, softwares are not patentable at all unless and until they enhance the efficacy of a machine, the system, or the mobile. Aesthetic creation is not an invention, since aesthetic creation is already protected under different laws. For example, copyright laws, Design Act. That's why aesthetic creations is not patentable. Mental act and rule of method is not an invention. A mere scheme or a rule of a method of performing a mental act or a method of playing a game, it is an art. That's why it is not patentable. Presentation of information is not patentable. You are presenting any information in a decorative way. It is not patentable because it is just only a presentation of presentation is not aiding to the usefulness, non-obviousness, anything, or not producing something at a cheaper rate. The topography of integrating circuits is not patentable. It is for the same reason it is protected under the different acts. Traditional knowledge is not an invention. It is also not protected because it is protected under different acts. And traditional knowledge is also not protected because it is the knowledge of all the peoples, not common individuals. Not patents are not like that. You use what your ancestors are doing and just put it in a paper and get a patent. That's why the traditional knowledge is for everybody. Everybody can utilize. You cannot prohibit anybody from uh, making use of the traditional knowledge. Atomic energy inventions are not patentable because for the security of the states. Section 4 deals with what are not patentable. So basically, what I explained here just a few moments ago is that what falls under the patentable subject matter. I explained the statutory what are patentable and what are not patentable. Most of the copyrights, designs, or traditional knowledge or integrated circuits are protected in a different way. Traditional knowledge is for all. Geographical indications is associated with the particular locality. It is for the use of the people living in that area. Geographical indications are protected under different laws. Regarding novelty, it's a novelty, non-obviousness, and usefulness. It is a very subjective type of thing which I can't explain unless and until an example is provided to me, or I prepare an example where all the audiences can understand. So, concluding here, what are patentables and what are not patentables, I forward to the types of applications which are submitted under the Indian Patent Act. Under the Indian Patent Act, there are ordinary application. Ordinary applications is any application which is filed by an Indian without claiming priority from a foreign application. Convention application is an application which is filed in any member of the Paris Convention. Suppose there are around more than 100 countries a member of the Paris Convention. They can file convention application within 12 months of filing the original application, the basic application, the priority application. PCT national phase application is filed after a person applies for an international application. International application is filed within filing 12 months of the ordinary application. Suppose I am an Indian, I file a patent application today. Today is 24th of July. Within 1 year, 24th of July 2023, I have to file an international application. After filing the international application from today, from 24th July, within next 30 months or 31 months, depending upon the jurisdiction, I have to go to the national phase application and PCT contracting states. PCT contracting states are those states which are member of the PCT, which are members of the Patent Cooperation Treaty. Original application is filed generally after the instructions of the controller when it is found out that there are that under single patent application you have applied for, basically 2 inventions are existing. Patent of addition is generally filed when you have filed a patent application and you have made further innovation in inventions, further improvement or a modification in that patent. So filing date in the patent of addition is the same as the original patent application. National and international patents, they are nothing like international patents. Only there are national patents. Patents are territorialized. It may be possible that you may get a patent in India, but you may not get a patent in United States or European Union or any country. So if to maintain patents, you have to also pay annuity every year. Patents are bound by the law of the country. Some patentability criteria, which I mentioned earlier, differ in different jurisdictions. So suppose horticultures or plant varieties are plant varieties or etc. etc. Some things are protected under USL law, may or may not be protected under the Indian patent law. So for college students or researchers, I must say that key understanding of the patent law is very much necessary, for the simple reason that whenever you are doing research, you know what are the inventions or what are the technological standards prevailing in that domain. If you understand the patent uh, how to search the patents, how to use the tools like Google Patents, Lens, or a paid patents or paid patchia, then you can research, create a landscape of what are the technological technological standards in that domain. You can do a better research. You may also know that whether I am reduplicating my just researching on a topic which is already well researched and patent is existing in that domain or not. तो अगर आप पेटेंट में मल्टीपल रिसर्च कर रहे हैं और ऐसा होता है कि मनी बहुत ज्यादा इन्वॉल्व है और आप पेटेंट टूल्स का यूज करते हैं, एंड यूज करने से आपको सबसे बड़ा जो बेनिफिट मिलेगा वो बेनिफिट ये है कि आप जो पहले से ही रिसर्च किया हुआ है जिसको पेटेंट एग्जिस्ट कर रहे हैं उसकी फाइन लाइंस को जान सकेंगे। फाइन लाइंस जानने का मतलब ये है कि आपको रिसर्च कहाँ करना है वो आपको पता रहेगा। अगर आपको ये पता रहेगा कि आपको रिसर्च कहाँ करना है तो आप जो अपना टाइम लगा रहे हैं जो भी थीसिस प्रिपेयर करने के लिए 5 years और 4 years, जो भी पीएचडी करने के लिए जो भी रिसर्च टाइम लगा रहे हैं वो एक अच्छी जगह लगेगा। और अच्छी जगह लगने का मतलब क्या है कि डेफिनेटली आपने कुछ नया ऐड किया, आप पुरानी ही रिसर्च को बार बार रिपीट करके और एक डिफरेंट प्रेजेंटेबल फॉर्म्स पे ला करके पीएचडी की डिग्री नहीं ले रहे। और फर्दर कैरियर अपॉर्चुनिटीज इन पेटेंट लॉ कैरियर अपॉर्चुनिटीज बहुत सारी हैं। आप पेटेंट एनालिस्ट बन सकते हैं, यू कैन बिकम ए पेटेंट एजेंट। पेटेंट एजेंट बनने के लिए सिंपल सी आपका साइंस बैकग्राउंड होना चाहिए। यू मस्ट बी वेदर बीएससी, एमएससी, बीटेक, एमटेक, ये बेसिक क्वालिफिकेशन बेसिक रिक्वायरमेंट है। 21 years की एज होनी चाहिए आपकी, एंड देन यू हैव टू क्वालिफाई द पेटेंट एजेंट एग्जाम। पेटेंट एनालिस्ट में जस्ट आपके पास रेलेवेंट आर्ट में डिग्री होनी चाहिए। फॉर एग्जांपल आप बीटेक इन इलेक्ट्रॉनिक्स हैं, देन यू कैन बी ए वेरी गुड एनालिस्ट ऑफ इलेक्ट्रॉनिक्स पेटेंट। सिमिलरली पेटेंट ड्राफ्टिंग के लिए आपकी क्वालिटीज, पेटेंट ड्राफ्टर की कुछ बेस्ट क्वालिटीज ये है कि आप अगर मास्टर्स अगर आप सपोज बीटेक इन इलेक्ट्रॉनिक्स है, देन यू कैन बी ए वेरी गुड ड्राफ्टर ऑफ इलेक्ट्रॉनिक पेटेंट्स बिकॉज यू अंडरस्टैंड द टेक्नोलॉजी इलेक्ट्रॉनिक्स। ए person in biology domain or life sciences domain will never ever be able to draft a patent much better than a person in BTech electronics, because the patentable subject matter is electronics, not life sciences. And you can say vice versa also. एक life sciences का patent एक person जिसने BTech इलेक्ट्रॉनिक्स में की है वो कभी नहीं लिख पाएगा, कभी लिख लेगा बट बहुत अच्छे से नहीं ड्राफ्ट कर पाएगा। सिमिलरली पेटेंट वैल्यूएशन कोर्सेज कोई भी परस्यू कर सकता है। पेटेंट वैल्यूएशन कोर्सेज में गवर्नमेंट ऑफ इंडिया कुछ नॉन इंटेंजिबल एसेट्स की वैल्यूएशन के लिए कोर्सेज लेके आती है और स्टैंडर्ड्स होते हैं। उन एग्जाम्स को पास करने के बाद से पेटेंट वैल्यूएशन कर सकते हैं। स्टैट्यूटरी पेटेंट वैल्यूएशन एज पर वाइपो भी होती है, वाइपो की गाइडलाइंस के थ्रू भी होती है। बट अगर आपको एक बेटर वे में पेटेंट वैल्यूएशन करना है जो कि एज पर इनकम टैक्स एक्ट है और एज पर डिफरेंट एक्ट्स को कंप्लाई करता है, देन यू हैव टू बी ए पेटेंट वैल्यूअर और इंटेलिजिबल एसेट्स वैल्यूएशन। सो इंटेलिजेंट एसेट वैल्यूएशन करने के लिए आपको एक रजिस्टर्ड वैल्यूअर बनना पड़ेगा। उसके लिए सर्टिफिकेट्स आती है जो कि गवर्नमेंट ऑफ इंडिया करवाती है। और आई सपोज की अगेन पेटेंट मोनेटाइजेशन सर्विसेज, आप पेटेंट मोनेटाइजेशन सर्विसेज में एज ए कैरियर बना सकते हैं। बिल्कुल aid in ongoing research as previously explained। आप आईपी ऑडिट कर सकते हैं। आपकी आईपी ऑडिट आईपी वैल्यूएशन प्रॉपर है नहीं है उन चीजों को जानने के लिए। वेल suppose ki it is sufficient for students, and I can't explain much more because everything will go. You will not be able to understand when I talk about the patent laws or anything unless and until you have a basic understanding where we can discuss. Any questions? Hello, Sabrina. Any questions from the audience?
So, hello. So, am I audible?
Yeah. Yes, yes.
So, as you've covered everything, so but then there are certain basic questions. That is, when cannot a patent application be withdrawn in India, and what would be the procedure for it? Like,
Yeah, patent can be withdrawn anytime, but the main question is here ki whether it is advisable to be to withdraw the patent or not. Patent or a patent application. Suppose you have filed a provisional application and you did not file complete specification. That patent will never be published. That is appended. You have filed a complete specification and you have an option to withdraw that patent within 15 months of the filing of the patent. That is before publication. If you think that your research is not completed, so you can withdraw your patent application within 15 months if you do not want let your invention become prior art. Let what you have submitted in the patent application become prior art. So it is a secret between the patent authority and you. You can withdraw patent. And apart from that thing, even if after the grant of the patent, you can withdraw. You can file you can surrender your patent, or before grant of patent, you can file the patent withdrawal applications. I suppose it is sufficient for the students.
okay, so and another thing that could be of utmost important guidance for the listeners would be, so as you've already explained the career options in relation to patents, but like if someone from the legal field is looking for a career option, what are certain important aspects that a person should keep in mind if they want to pursue a career in patent litigation itself, solely in patent litigation, considering that they're not eligible to become a patent agent?
Basically, advocate possess all the qualities, but what they have to learn is that what is the inventive part in the patent, uh, what is the inventive part in the patent, and whether it has a proper disclosure or not. So for that thing, he has to learn how to interpret patent and what are the inventive concepts for which patents are granted. So that is the claim, understanding of the claims, understanding of the subject matter apart from the patent law. They possess all the qualities, but they have to research thoroughly on the technology, and apart from that thing, they have to understand how claims are interpreted. That is sufficient for them. Apart from that thing, they should try to draft a few patents, because already advocates have a very good skills, but they did not know how to use that skills in the patent law. I suppose this is.
Yes, sir. Let's answer the questions. And so, thank you for such an insightful session on patenting innovation and inventions, and also thanking all the participants and sir again for sparing the time to attend this webinar. Hopefully, it has helped everyone to gain a better insight into patenting innovations and inventions. And again, for all those of you who are interested, WCF is having an upcoming course on patents, which is open for registrations for everyone. The course is a 1 month long course on practical guide to patent laws. And as I already mentioned in the beginning of the session, that the course is available at an additional discounted rate. The uh, the the discounted price is 699 for the course, but those of you who registered today itself would get an additional 10% discount. And after using the coupon cyber learning 10, which, and the link for the same is given in the YouTube chat also. That's it from my side. Thank you again, sir, for your time, for your valuable time and insight on the topic. It was a very insightful session. Thank you, sir.